The Liquor License and Control Act, Statute of Ontario 2019. As if things weren't already confusing enough here in the province of Ontario, we now have a brand new act to figure out and navigate that replaces its predecessor that we were all too familiar with. Well, rest assured, whatever your level of discern or concern, this video will address all your most common of considerations and more, so stick around. Court is in session and you are on the stand with me, Brian Lass. Roll the intro. Oh, welcome once again. I am Brian Last, and of course, as always, if you have not already done so, I will extend the invitation from my side of the computer screen to yours and invite you to go ahead, click that subscribe button and bell notification icon below to ensure you are first in line for notification of videos such as these right to your inbox as I endeavor to update the channel in relation to any major applicable of scenarios that of course are relevant to the broader law enforcement and legal landscape here in the province of Ontario. And with that, we come full circle, and here we are talking all things to do with the LLCA, as you'll come to know it as. Now, I'll be honest, this video does come inspired by a host of, dare I say, panic-stricken officers that were sort of, out of left field presented with the idea that now we have this act that has replaced its predecessor version, the LLA, an act that we came to know all too well, that we had embedded in our heads as it came to navigating liquor-related offenses in the province. But I will tell you as an aside, and even on the notion that we have a new act to consider, for those who are, of most applicability being those in the regulatory side of house, this really is as exciting as when AHA first put out their music video for Take On Me. And for those who have no idea who AHA is, don't worry, your aha moment, pun intended, will happen when we jump into the PowerPoint presentation and start to really break this down bit by bit, all things to do with the LLCA, and of course, most importantly, how it relates in regards to, exactly its predecessor, what it's replacing, the LLA. So let's do just that through the magic of video editing in 3, 2, 1. And yes, welcome formally once again to the Liquor License and Control Act crash course, as we're calling it for police and special constables here in the province of Ontario. I, of course, am Brian Lass, former provincial prosecutor, current sergeant special constable. But with that being said, a quick little disclaimer, if you will, for certain, none of this is to be taken as legal advice. If you find yourself perhaps charged with a liquor offense, absolutely, perhaps seek counsel or a paralegal. And for that matter, although this reflective of my profession, this certainly presentation rather does not reflect my employer's past, present, or future. This is a standalone from yours truly, of course, to you in the interest of, for lack of better description, making your life easier. So with that CYA, let's get right into it and address, of course, the question of the day: what exactly is the LLCA, although we've somewhat alluded to it already. And quite simply, yes, it is new and improved in the sense that the Liquor License and Control Act, again, the LLCA, as you'll come to know it as, is, of course, a provincial statute dealing with licensing and possession of alcohol. This is new as of November 29th, 2021, just a couple months ago, really. And, of course, it did replace, which came as a shock to many, the LLA, or the Liquor License Act Revised Statute of 1990, for that matter, Revised Statute of Ontario 1990. Now, even with just that notion of 1990 many years ago, although there were some, minor Band-Aid solutions or updates, for certain there was no major overhaul of the framework from the regulatory side of house, being that for considerations of the AGCO, or Alcohol Gaming Commission of Ontario, and their, respective liquor inspectors, as for such example. So although I don't want to go into too big of a history lesson, quite simply, the LLCA does modernize the way for regulating the sales, service, and delivery of liquor. And undoubtedly, as again we've suggested many times already in this video, in light of this, certainly this does have effect for us, though, those of us out in a uniformed enforcement capacity, and that is exactly what we're going to talk about. So the good news with this being said, although we're talking about change and a new act and all the like, and I've always wanted to use this saying, Same, but different. Well, what exactly do I mean by this? Well, quite simply, as far as your, thought process, your considerations, pretty much it is going to stay exactly the same as when you were enforcing under the guise of the Liquor License Act. Now, different from the context, however, that there are some minor nuances, that being what we're going to talk about, in that, section numbers have changed. As for the biggest difference, the LLA versus the LLCA. Now, the LLCA does talk about the same, things, same topics, same offenses we've already dealt with, again, placed under different section numbers. And as well, there's been some minor nuances to the actual short form wordings of the offenses, or rather what you'll actually write on the face of a ticket or summons. And we're going to certainly address that in this presentation. And as well, a couple of very, very minor alterations to the long form wording. But again, to come full circle, as far as any earth-shattering, groundbreaking differences, there really is not going to be any. Everything pretty much stays the same as far as when you come across a scenario and perceive it to be a violation, in relation to liquor, if you will. Undoubtedly, it is still going to be that of a violation, but of course, you're going to want to figure out the applicable section numbers and things of that nature. And this will make a lot more sense as we go through the presentation. So, with that being said, where exactly do we start? Well, as one perhaps consideration, and of course, this is the Provincial Offences Act unto itself. Now, some of you might not be aware of this, but if you were to Google Provincial Offences Act or go right to the ELAW's website, if you were to click on the regulations, specifically that of Regulation 950, proceedings commenced by a certificate of offense, we use Control F at the top right of our screen there. You can see we typed in liquor, and wouldn't you know it takes us right to the new Schedule 61 under this regulation, and it'll give us all the short form wordings and their section numbers as it relates to the new Liquor License and Control Act. So this may be an easier way for certain for you to navigate through this and put your mind to where certain offenses are under certain sections, as for such example. Exactly. And for one such further caveat that maybe will assist perhaps a little bit more, if one is to go to the Ontario Court of Justice website, ontariocourts.ca/OCJ, at the very top, we click on Provincial Offenses. We go to the right and click on where it says Set Fines. Wouldn't you know it, there is a schedule under Set Fines 1. We use Control F again and type in liquor, and you can see it brings us up. Wouldn't you know it, not only the short form wordings, but all the associated subsections, section numbers, and as well the actual correlated set fines. Now, a lot of these no set fine, but you can see there are set fines set for a number of the offenses. Certainly those with no set fine, we can still enforce, but by way of a summons. But again, this taking it one step further, and certainly you can rewind this and pause this to make sure you know how to navigate this properly. But with that being said, you may be asking yourself, okay, well, this may give me the set fines, but how do I know what to fill in for the total payable? Don't worry, Brian Lass has your back, because I have provided a link in the box right below on this very YouTube page to a video I created, how to create, or rather how to calculate, I should say, the total payable. So there is a YouTube link. It'll take you to a video instructing how exactly you fill out what the total payable will be, dependent upon whatever the set fine is. So don't worry, I got your back in that regard. Now, again, to come full circle back to the LLCA, let's talk about some definitions. And conveniently enough, the main definitions we'll talk about here, all placed right under the interpretation section, 1 sub 1 of the LLCA, right at the start of the act. And the short version here, as far as what we've come to know as alcohol or beer or spirits or wine, and the all-encompassing definition of liquor. Again, there have been some maybe minor tweaks to some of the wordings here, but overall, what we have come to understand is any, one of these things that we may come across and see someone perhaps unlawfully using it, either having it open or drinking somewhere they shouldn't be, it's all going to be status quo in that regard. Arguably the most common of scenarios, and certainly why I've put it first here, the idea of place, possession, or consumption, or otherwise having open liquor or consuming it somewhere you shouldn't be. So what I can tell you, absolutely, the wording of this, and you may remember it, from its predecessor section in the LLA, but where it is now is in section 41 sub 1, and again, it does pretty much read the same. This idea of not having or consuming liquor in any place other than a residence. premises in which a license or permits consumption is issued. So again, a residence, licensed premises, or private place for that matter. And even the short form warning was have or consume liquor in other than residence, licensed premises, or private place. However, with that being said, the short form wording has changed for this as well as the section number, and we can now have one of either two offenses, each of which would still be section 41 sub 1. But we now have having liquor in open container in unauthorized place or consuming liquor in unauthorized place. So again, they've amalgamated these residence, licensed premises, etc. to just be categorized as unauthorized place. Now, as far as what we've come to know, as a definition of residence and private place and things of this nature, certainly it is pretty much status quo, although residence now placed in the interpretation section and not as a predecessor to this offense we just talked about. But what I will tell you what this translates into, and the reason I mentioned this specifically here is this still is an area of confusion. But if you read the definition of residence, certainly what it alludes to is that the LLCA, as well as its predecessor, the LLA, does permit drinking in common areas, such as this lobby we see here in an apartment building. Because again, residence means a place used as a dwelling, including all premises used in conjunction with the place to which the general public is not invited or permitted access. So with that being said, absolutely, if it's an apartment or a condo, you know, the general public is not just invited, permitted access. They have to buzz in, have a key fob, whatever the case is. So anything other, on the other side of that, accessible door or door you would need access to by virtue of any of these methods we talked about, other than the actual apartments or condos themselves, things like the hallways, the elevators, the underground garage, the lobby as well, considered common areas. So as such, if someone has open liquor or is drinking liquor there, again, they're actually allowed to be doing that, believe it or not. And as far as a private place is concerned, where we now find the definition of private place, it's in the regulation under the LLCA, OREG 74521 General. So private place, again, this reads pretty much the same as it did before. An indoor place to which the public is not ordinarily invited or permitted is a private place, except at the times when the public is invited or permitted access to it. So again, if you think about an apartment building, just as for such example, an indoor place to which the public is not ordinarily invited, meaning, the public cannot come and go like that picture at the bottom left here, like a mall. People can just come and go as they please. Certainly that's not the case. So that would be one such comparison. And on the right side of the screen, applicable to subsection 3. So despite subsection 2, an indoor place that is available for rental by members of the public for occasional use is not a private place. And the reason why I put this party room here of an apartment or condo building, we need to put our mind to the idea that, albeit this is available for rental, it is not so by members of the general public and plausibly only available for usage of persons who are actually tenants or live in that building. So certainly if it was... it would be considered a private place if it was that such caveat. So just something else to put your mind to. Now, as well, still on the notion of private place, this regulation does start to talk about other considerations for, RVs that are parked, are being used perhaps as a residence at the time, or boats with sleeping, quarters for that matter. And again, this may be more applicable to that of someone, let's say, as a conservation officer. So I did just give it honorable mention here, and certainly as you look through the definition of private place under that regulation, you'll be able to see this for yourself. And nothing changes as far as, obviously, you're going to want to record as much detail about this respective offense of either having or consuming open liquor somewhere that is considered unauthorized. So a lot of this sort of a no-brainer. I won't go through it, although I will give honorable mention. Of course, you'll always want to mention if it relates to, let's say, this tall boy of Pabst Blue Ribbon. What was the alcohol percentage per volume written on the actual can? That is probably something important you'll want to notate. For whatever reason, a lot of officers seem to forget that. And as an aside, as far as, seizing alcohol, in the case of, someone drinking an open Pabst Blue Ribbon, we, of course, do not have to seize this and carry it around with us if we're, walking the beat. Obviously not practical. The courts appreciate this and have taken the same view as well. But for certain, one thing you may want to do is actually, as sort of alluded to in the bottom there in yellow, absolutely, if you carry around a work iPhone or work camera phone, of course, you can take pictures of this, and certainly they'd be admissible under the regime of RV Baptiste for admissibility of photographs as for such example. Now, as an FYI, and please note as it relates to this idea about dealing with someone or charging someone for consuming or having open liquor in an unauthorized place, you do not have to prove who owns the liquor. Just observe that the open liquor is actually in the defendant's possession and that they have and or are consuming it. And don't forget, and again, just as a quick FYI, and we talked earlier about the idea that, it's actually not an offense as far as the LLCA is concerned with the definition of residence to be having or drinking liquor in these common areas. So even if we had a scenario like this with that signage now posted, no drinking, a picture of the martini glass, this certainly being sufficient notice, that red universally recognized do not do sign. And here we have this gentleman, what we perceive to have a bottle of beer. Even in this such scenario, regardless of the signage or not, this is still a common area. It's in the hallway of one of the floors there, I guess floor number 3. So this still does not formulate an offense under the LLCA. However, and just as an aside, if you find yourself in this such odd predicament, what would the appropriate charge be? Well, being there is sufficient notice, proper notice as far as Section 5 and 6 of the Trespass to Property Act is concerned, this would actually formulate an offense of engage in prohibited activity on premises. So I just want to give this, again, honorable mention should you find yourself in the realm of this such peculiar predicament. Now, intoxication, shifting gears here to yet another section, another consideration under the LLCA, much like it was a consideration under the LLA. And for certain, when we're dealing with all things intoxication, as an aside, stating the obvious, we want to, of course, proceed with caution and make sure that whatever this intoxicated state we perceive is not a medical condition. Maybe the person is in a diabetic shock, maybe they have a brain injury, or maybe they're having a stroke, as for such example. And with that being said, intoxication now finds itself under Section 31, Sub 1 under the LLCA. And I'll tell you, it pretty much reads the same as the LLA, but we've kind of split this up in twofold, if you will. Again, much like we had previously. And we have the offense either of being intoxicated in public place or being intoxicated in common area of residence. Now, each one will have its actual own section number, either 31 sub 1A or 31 sub 1B. And the one thing I want to mention, although it may seem a little confusing, we can't charge someone for having or consuming liquor in anything that would be considered a residence or these common areas of an apartment or condo building. Well, guess what? With intoxication, that is the only of scenarios that we can actually charge someone reflective of something under the LLCA, being that it does have its own consideration under paragraph B, any part of a residence that is used in common. And again, it'll be one of these two offenses, either public place to which the general public is invited, or intoxicated in common area of residence. And of course, stating the obvious once again, you'll want to record as much detail about the offense, obviously all the demonstrable signs of intoxication, etc., etc. But the one thing, obviously, we want to be considerate about, to be intoxicated, the courts have stated that this is a stupefaction by alcohol to the point where the person has lost capacity to prevent him or herself from causing injury to him or herself, etc., etc. So certainly if we're dealing with someone in the realm of intoxication, we are plausibly dealing with a safety concern. This person has to be very, very drunk to be considered intoxicated, and all alluding to the fact that maybe we want to deal with this more from the angle of getting this person the help that they need, as opposed to, really considering a charges for such example. And again, conveniently enough, wouldn't you know it, much like the LLA stated, now we find under Section 48, which is formally in the LLA and Arrest Authority, but here, 48 sum 1 is where we start to talk about taking to hospital in lieu of an intoxication charge. So absolutely, we're dealing with someone that we believe, or rather apparently, as far as one knows or can see, apparently is in this intoxicated state. We can actually take him to the hospital to get the help they need, instead of just saying, hey, here's your ticket, go off on your way, which we shouldn't be doing, which I'll talk about in a moment here, or any other such consideration. However, we've all come familiar with the term, somewhat of a negative term called the drunk tank, if you will, and just to demonstrate, understanding of where I'm going with this here. We do find ourselves now under Section 31 sub 2, the first of two arrest considerations here, this one being solely and specific to that of dealing with an intoxicated person. And again, pretty much reads the exact same as it did under the LLA. The one thing I will say, as far as aggressive intoxicated persons, if they are safety concern to others, in those such caveats, potentially that is when we do want to take someone, to the respective police division to be held overnight till they sober up. Things, with that such egregious associations where we don't believe it's feasible to take them to a hospital otherwise, as for such example. So just another consideration to navigate accordingly. And one other thing, listen up, pay attention, take note for certain, still on the topic here of intoxication. Absolutely beware when releasing someone from the scene if you do decide to, whatever reason, charge them with intoxication and let them go off on their merry way. Because, of course, guess what? Like this individual here that we let go at the scene, they're drunk, they stumbled off, they're getting hit by a car. Guess what? A ticket or a summons will be in the person's pocket with your name on it. So for certain, again, my best advice, and this is a consideration both for the predecessor LLA and still present day, obviously we want to make sure that as far as intoxication is concerned, we're dealing more from the angle of just trying to get this person the help that they need. So now we get into the wonderful world of motor vehicular related LLCA type offenses, much like we had in the LLA. So everything here is pretty much status quo as it was in its previous version. We now find this, however, under section 42 sub 1, conveying liquor in motor vehicle. This relevant to perhaps having open liquor or reasonable grounds to believe there's open liquor unlawfully, had inside a motor vehicle, or for that matter, that is, perhaps readily accessible. Certainly this beer store box, being that it's closed, not necessarily accessible. Believe it or not, you can actually have that in the car. However, if it was opened and otherwise readily available, certainly this would form plausible grounds for an offense for conveying liquor in motor vehicle. The one honorable mention I'll give here, although this is certainly a consideration we can navigate under an array of offenses under the LLCA. Arguably, if we're dealing with anything to do with liquor and motor vehicles, you're plausibly going to examine it from the angle of under the criminal code as it relates to care and control and all the things of the nature, again, from the criminal context. But this section, certainly does have applicability in various contexts, and that's what we're going to examine very quickly here. So I'll just show you can see the wide array of different offenses you can have, all as it relates to just that predecessor section under section 42, driving motor vehicle with open container of liquor, having care and control, etc., etc., etc. But certainly the point I want to get at, first and foremost, as far as the elements, stating the obvious here, the person cannot be a passenger of the vehicle. We have to demonstrate either driving or having care and control, have to prove the person's the driver. Maybe they're outside of the car with the car keys in their hands, etc., etc. And of course, we also have to prove the open or unsealed liquor part of the equation. But certainly the point I want to get at, if you do have reasonable grounds to be sort of exploring any of these such offenses, there is a associated search authority. And again, this search authority, search of vehicle, has actually been separated from that of search of boat, if you will. We haven't listed the boat caveat here, but just, still under 42, there's a separate section that talks about boats unto themselves. But here, still on the topic of vehicles, the vehicle component, pretty much the same as far as your search authority as it was in the Liquor License Act. And the reason I want to give honorable mention, again, certainly we can, without warrant, search the vehicles and all persons in it if we have reasonable grounds to believe these such caveats of, a conveyance or unlawful conveyance of liquor in a motor vehicle is happening here. But a couple of honorable mentions as well I want to give that you may not otherwise be aware of, which again may have applicability, and certainly the reason why I want to mention it here. Being that the search can extend itself to the trunk area. However, it is strictly for liquor. And again, in the matter here, RV Annette, basically what happened here is, was one of these such caveats and investigation of perhaps liquor being unlawfully kept in the vehicle. They obviously wanted to prevent the continuation of the offense and, explore if there's maybe more liquor, beer, or whatnot available, accessible in the trunk. But wouldn't you know it, when they got into the trunk, there was a large quantity of cocaine. And ultimately, when it made its way all the way to the Ontario Court of Appeal about whether or not this was a violation, unreasonable search and seizure under the Charter, it was determined that, this search authority can reach to the trunk, being that the person was there to be searching for liquor in relation to that unlawful liquor offense relating to the motor vehicle. So this is one such consideration you may not have otherwise known about, and of course you want to make sure you're articulating your search accordingly. But conversely, however, on the other side, RV Mpamugo, I believe is how it's pronounced, certainly your search of the vehicle has to be reasonable. If you're looking for bottles or cans of beer, it's not going to extend under a floor mat as pictured here, and that's exactly what happened. There was some illicit drugs, I believe, that were found under the floor mat, but it was determined it's not reasonable to be looking under a floor mat and say I'm looking for liquor. So obviously that's something else you want to put your mind to. And shifting gears a little bit here, talking about unlawful consumption or supply of other alcohol, and this empathetically perhaps being in relation to certain marginalized communities, dependent where you work, there's maybe an unfortunate scenario that comes up. So much like this was mentioned in the LLA, we do have the same consideration in the LLCA under Section 37 about drinking alcohol in a form that's not liquor, etc., etc. And there's a few variations respective of paragraphs A, B, and B as well. A, B, B, if you will, all under Section 37. And this is drinking alcohol in a form that is not liquor, supplying alcohol in a form that's not liquor, knowing of intention to use as a drink, and ultimately supplying alcohol in a form that is not liquor when intention to use as a drink ought to be known. And switching gears here to the underagers, if you will, and again, much like we had this consideration under Section 30 sub 8, I believe it was, under the LLA, we now find this under Section 34 sub 1, very simply speaking to that of either having, consuming, or attempting to purchase, etc. All things to do, really, if you will, with persons under 19 and liquor. And you can see, although there's various variations of the short form wording that can come out of this, they're all going to be Section 34 sub 1. So seizure authority, and again, I'm going to sound like a broken record. This is of the same consideration as far as seizing evidence in relation to offense to prevent continuation and all the like. Again, this section reading pretty much the same as the LLA. However, where we now find it is under Section 61 sub 1. So at a high level here, your seizure authority stays the same, and the same goes for a continued seizure authority, liquor in presence of offense. Section 61 sub 2, going on to talk about the scenarios that you can certainly seize this liquor and perhaps any containers it's kept in, etc., etc. So again, we have the same consideration. It's the same thing as we had put our mind to under the LLA, but now we find it under Section 61.2 of the LLCA. And our second of two arrest authorities, and again, stands as the same sort of consideration as where it once was under the LLA, under Section 48. Now, arrest without warrant. So basically, this alluding to this, fail to ID, as we more commonly call it, clause. As this individual here tries to fool the investigating officer. My real name is Richard Cranium. Some of you may get that, some of you may not. But nevertheless, arrest without warrant, still reads the same as it once did, but now under where we now find it is Section 62 of the LLCA. And penalties, and if for no other reason to present this to you as considerations, being that certainly if we do commence a proceeding under Part 3 in the most egregious of circumstances under the Provincial Offences Act, you can see that, of course, now opening the world to maximum penalties prescribed by statute. And for a corporation, it's no more than $250,000. And for individuals, up to $100,000 and even up to a year of imprisonment. And this speaking to offenses other than those found under Section 33, which is, I believe, sale and supply of alcohol to underagers. But interestingly enough, and again, speaking to the most commonest scenarios you'll come across, there is an exception. Any individual who's convicted of an offense under 31 or 41, so certainly either intoxication or drinking in an unauthorized place, imprisonment's actually off of the table. So again, any scenario of someone intoxicated, or I don't know why you'd be doing that in front of an officer. I think that was a prank, actually, that bottom right photo. But nevertheless, imprisonment would be off the table. And again, this being your consideration, because of course as officers we are conferred with discretion, and we want to navigate that accordingly based on the totality of circumstances, aggravating, mitigating factors, things of that nature. And for the purpose of this video, that is our ending point. So I certainly hope you got something out of this, and this makes a little bit more sense. And as always, a huge sentiment of recognition, appreciation, acknowledgement, respect, gratitude, honor, and thanks to each and every one of you for continuing to provide all the amazing feedback and comments, and for watching and engaging with these videos. I do look forward to seeing you in the next one. Thanks for tuning in, and stay safe out there.